right, at this point, we're going to skip number 5 and move to number 6. Public hearings to consider proposed revisions to Greene County zoning ordinance, Article 16-2, special use permits and all applicable references to amend language and regulations applicable to the special use permit process and approval. This is ordinance revisions number 15-002. Mr. Svboda.
Thank you, sir. As you stated, this is ordinance revision 15002. This is item 2 on our work program back from February or March, I believe. We did hold actually 2 public hearings with the Planning Commission. One on April 15th, also one on September 16th to go through this particular revision. Also, the county attorney has weighed in on the language because of the nature of the permit and because it comes to the Board of Supervisors. I will run through sort of the language briefly. What we did is sort of clean up that section. If you look at the old section, there's only one category, which is special permits. There's no other category in there until you get to, actually that's it. There's no other categories within that old language. So one of the things that we found through our pre-application meetings is that it's been confusing to the applicants on what's the application section, what's the process section. So the titles that you see there, 16-12 applications, that explains that portion of the process. Public hearing process, about notice, about going to the Planning Commission. That's number 2, 16-2, the public hearing process. So some of the language we were able to keep. Most of the language was rewritten to conform with state code and the way we do things. Instead of referring to a docket, instead of talking about a public hearing, we were specific about Planning Commission. We were specific about Board of Supervisors, when it goes, how you do the advertising under 15.2.2204. All those things under process. Also under factors to consider, they're in the old ordinance, but it's not clear on what the governing body is looking for. So the factors to consider, A, B, C, and D that you're looking at, those are the same factors that were in the old ordinance. There was no additions there. We changed the word shall to will. That was the only change the Planning Commission recommended there. So in the intro sentence, the Planning Commission and the Board of Supervisors shall consider, but not be limited to the following, was something that we noticed during pre-apps. Well, is this the limit? Can I only consider these factors? Are there more different things? Because a special use permit is special by nature. So being special, it gets special consideration. It's looked at differently than a by right use under the Code of Virginia. That's why those factors are in there. That's why those things were in there. So those A, B, C, and D, and actually both sections are pretty close to the same or similar to what was in the old ordinance, or the existing ordinance, I should say. It is not old yet. 624 conditions. These are sort of guides for what the board has put on applications in the past. What we did remove, and I'm going to go through that pretty quickly, is there's a requirement that talks about fire hydrants. RSA deals with fire hydrants and site plans and things like that, so that's an RSA thing. There's another requirement in there that says the building official shall inspect the special use permit annually. We know that the building official inspects buildings. If we want them to keep inspecting, and this is I think a conversation me and Mr. Borders had some time ago, that things that are subject to the building code, the building official will inspect. Things that are subject to the zoning ordinance, zoning administrator would inspect. So those are things that we try to clean up and clear up, because those are already things that are required by code. If I get a permit to build something because I got a special permit to allow it, that's already reviewed by the building official. It already is reviewed by that department. Same thing with health department requirements and different things. So those are some of the things that we took out. Under conditions, it said provide for adequate, and we looked at a provision for adequate parking if it was required. So not that it was automatic, but if the use for the special permit triggered the need for that, then it would be required. So those were the guidelines. We tried to clean that up to make sure that the applicants understood the process by reading it. That's the feedback we were getting through the pre-application conferences. The two newest sections are 1626 existing special permits. There was nothing in our ordinance that addressed existing special use permits, whether they vested or how they vested or different things. So that particular section, it talks about if your permit is more restrictive than the code, then you got to meet your permit. That's based on the advertising and the notification that was done for the public. Also, if you look in there, it says if any condition of the special use permit is less restrictive than the applicable article in the zoning ordinance, and the applicant has vested rights, meaning they vested that use, and have attached the approved use to that vesting, then the special use permit conditions apply, meaning if the ordinance becomes more strict, but their permit is less lenient, they get to go with the less lenient permit. So that was an effort to protect the applicants and the businesses with the approvals that they were granted as we went through the process. There's nothing in our ordinance currently that addresses that situation. So that's to clarify how they vest in that use.
Like a grandfather.
Yes, exactly. Because they're special permits, they're not non-conforming. So they're actually conforming uses. So to try and clarify some of that already confusing language within the state code, we proposed that, and that's what the Planning Commission approved. 1627 talks about the revocation of a permit for non-compliance. That's only if the Board of Supervisors determines that there has not been compliance with those specific conditions. You can't revoke a permit just because. They have to be in violation of conditions of the permit, not for something else. That's case law, that's Virginia code. So that is to be clear about what the board can do and also what the applicant can expect in their approvals from the governing body. That's kind of it in a nutshell. Again, we went to the Planning Commission on April 15th, 2015. We also went back to the Commission with a second public hearing on September 16th, 2015. Unfortunately, at both of those meetings, there was no public comment at those meetings. So we were solely based on our conversations with the Commission and the County Attorney.